As if separation isn't difficult enough, determining property settlement is a whole other story. It can be quite tricky to figure out who gets what. So tell me, Diane, how do people at the court work out a fair property settlement?
So there's a process in working out a property division, and the process involves 4 steps. This first step is to look at what property is there, to look at the assets and liabilities and what their values are. So when we look at the assets in step number 1, the court will allocate a second-hand value. So for example, furniture. What you paid for it, someone else isn't going to pay for it.
No.
If you put it all out on your front lawn in a garage sale, what would the market tell you you'd get for it? In terms of real property as well, that is market value. So if of course the property market's not doing well, it's the market that you're in at that point in time, at today's date, if I can put it like that, or at the date of the agreement. So in relation to other things, there's shares, bank accounts, cars, all of that. So I really say it's your bricks and mortar, you can sell it. So it's those things that you can sell and you can get something for today. The other thing that is an asset that's considered in step number 1 is superannuation, and the value at today as well is considered. So the court will see and have a look to all of the assets and all of the liabilities and also the superannuation. But as I said, it's a market value. So that's the first step. Then the court moves to the second step. And if I can put it simply, that step looks at contributions. And people sometimes think that contributions are just, okay, well, this person paid the mortgage, so they're entitled to more. That's not technically the case. Contributions that the court looks at are financial, non-financial, and homemaker, carer, and parent. So if someone stayed at the home and looked after the children and the other person went out and earned an income, completing those family and homemaker tasks are taken just as equally as going and working. It's really one of those things where the court will have to look at whether there's been some lump sum awards, inheritances, and things like that. But really what the court looks at are financial contributions, non-financial contributions, and homemaker, carer, and parent contributions. So that's step 2. So the third step is to consider the future needs of each of the parties. And at this step, the court looks at a number of things, but the main ones are their age, their earning capacities moving forward. Is someone going to have the future obligations to care for the children, and also health? Now those are the main ones. There are many more, but those are the main ones. And the court steps through that to work out, does someone need to get a little bit more of the property pool because they're not able or in the position that the other person is in to re-establish themselves more easily? Finally, what the court does is they then stand back and they've looked at the assets and liabilities, and as I've said, superannuation's an asset. They've then looked at the contributions that each of the parties have made. They then look at the future and they essentially stand back and decide, well, based on all of that, what's a fair split? Now, if people are doing reading on the internet, they'll see the words just and equitable. And that's what the step number 4 says, doing a division that's just and equitable, essentially. But in other words, that's just what's fair, if I can put it that way.
So how did the court say what is fair then? Because
well, what will ultimately occur, and for those people who have separated and they sometimes give assistance to their friends, which is absolutely fine, but they refer to percentages. And people say, well, I got 50-50, I got 60-40, I got 55-45, there was a 70-30 split. What that means is the court will allocate essentially a percentage based upon that 4-step process.
Yep.
And when they allocate that percentage, they'll then say, as part of that 60% or 70% or 50%, whatever they decide, as part of that percentage, I've calculated that you will get this of the property pool and the other person will get this of the property pool, and the liabilities will be distributed like this. So that's why they do step number 1, because then they can, at step number 4, once the percentage is worked out what 60% is, to then be able to allocate what the person's going to get.
So is the split always 50-50 or it does vary a lot?
So there's no automatic presumption that assets will be split 50-50. The contributions and the future needs of the parties have to be considered, and then an assessment will be made on what the percentage distribution will be. The fact is that every situation is unique, and it's important that the person get legal advice specific to their circumstances, because there may be something that's different in their circumstances to what their friend had been telling them.
So as you can see, there are several myths about property settlement, and it is, quite challenging. I think you definitely need to consult a lawyer. So go and see the team at Ruhl Family Law Centre today. They'd love to help you through the minefield that is property settlement.